All right, good afternoon, everybody. My name is Robert Piewski, and I'm founder of Beyond the PhD. And I'm really excited to be hosting Dana Bucin today to talk to us all about the visa process and continuing your education in the United States. I had the opportunity of meeting Dana a few years ago now when I was a PhD student at University of Connecticut, and I thought, well, one of these days I will have Dana talk to us about the visa process, and today is that day. Uh, Dana is a immigration attorney at Murtha, Cullina, located in Connecticut, and she is the chair of the immigration practice. She's extremely vocal and present on social media, and she will share some of her platforms that she uses, especially LinkedIn, as well as Facebook. And I encourage you to follow her online to learn more about immigration rules and status. And I hope that you follow her for that. And so without further ado, I'll have Dana share her screen and we'll get started. Again, I ask you to please put your questions in the chat. You can either direct message me or direct message the whole group, and I will moderate that for today's session. Please remain muted for the presentation, and thank you for coming.
Thank you, Robert. I just want to take this opportunity to thank Robert because it takes people as excited as he is about immigration law and policy to make this known to you and to bring people like me to speak to you. And if there's anything I learned in my career as an immigration attorney is that it is people like Robert that make it possible for resources to migrate to you. And it's about caring about your destiny as international students who are navigating all these complicated ways of immigration policies in the United States. So thank you, Robert. And I wanted to start, Robert, if you could assist me a little bit. I wanted to get a feeling for who's in the room and what type of statuses they have. So I'm going to assume that everyone here is in F1 student visa status, unless someone tells me that they have J1 or other statuses. So anyone here with non-F1 statuses? You could
you could raise your hand or put in the chat. You can put, so we got J1, yes, J1.
I see J1, okay.
And we got a few people raising their hands saying that they're J1.
Yep, J1, okay.
F1, but OPT.
All right. Next up, I want to, all right. I get it. Okay, so it's good. I'm going to focus mainly on F1, but I also, because I kind of had a feeling I did include some slides about J1 visa. So I'm going to go ahead and share my screen to start my presentation so I could teach you the 101s of immigration law in the United States. All right, there. Let me see if I could share it as a slide. Okay, so I would have to, it would have to be.
Should be slideshow up at the top or the little screen button down at the bottom of your screen. Oh.
Don't know what happened here. Hold on. There.
It still looks like we're in an editing view.
Okay. Let me stop share first and then figure out. I'm going to put it on slide share first, and then I'm going to share my screen.
Sounds good.
All right, so let's see, view, slide. Slideshow. All right. And oh no, that didn't work. I apologize about that. That did not work. Okay, no problem. The system doesn't like the slide share. Okay.
So if you go back to the view that we had before, there should be like a little projector button at the bottom of your screen.
Okay, there. Share. We're going to keep it. Okay. Why make it full screen? Do you see it as a full
I
screen?
do. So what I just sent a
Okay.
request for me to control your screen.
Okay, approve.
Okay.
All right. So now. There. Thank you.
Oh, no problem.
All right, so Dana Bucin, I've been properly introduced. I do, besides immigration law, also practice international business law, which is going to help me in explaining to you some of the more business and entrepreneurially oriented visa options. I do all these practice areas that are related to immigration, international business, corporate business law. Went to Boston University School of Law, undergrad at Ohio Wesleyan University. You should know about me that I am not only a immigration attorney advising international students as a professional, but personally speaking, I've gone through the same journey that you are going through right now. I was an international student myself. I did all the types of visas I'm about to explain. Most of the visas that I'm about to explain, I did them personally. I am originally from Romania. And so with that background, I could relate to you guys, not only professionally, but also personally. All right, so let's start a little bit on transmitting some wisdom to you. I'm going to give you some general impressions about what you should be doing because it's good for your immigration health. And one of the first things I tell people is we are in a time when the consular processing doesn't function as quickly as it used to be. They're just redressing the labor shortage they've incurred during the Trump era and COVID. So they're just getting up to speed with consular officers in consulates abroad. So if you don't have to go to a consulate to renew a visa or to apply for a new visa, it is preferable that you don't. So avoid international travel that would trigger a need for visa renewal. That's not all international travel, because if you have a valid visa in your passport, you could keep going back and forth, in and out. That's not a problem. It's just when your visa expires and you choose to travel internationally, you're obligated to go to a consulate abroad to obtain a new visa. And that's what gets people in trouble these days, because consulates could take months to process certain types of visa renewals. Okay, so, and I don't want you to be caught abroad, stuck abroad without the opportunity to come back. All right, another pearl of wisdom before we even start is it's always best, it's a corollary to the prior slide. If I want you to avoid consulates, is because I want you to manage your own immigration process on US soil. It's much easier for me as a lawyer to obtain status for you when you stay on US soil rather than when you internationally travel to go through a consulate. And there are ways to do changes of status on US soil without having to depart and visit a consulate. Also consider smaller employers, entrepreneurship, or self-petition, because these are the categories that give maximum flexibility to your visa journey in the United States. Obviously, nothing can be done without a competent and creative immigration legal counsel. This is essential. Immigration legal system is very complicated. There's 26 types of visas, basically at least one for each letter of the alphabet. For some letters of the alphabet, there are like 4 visas. I mean, the H1s, the H2s, the H3s, the H4s, for example. Not only that, but there's also over 20 types of green cards. So which one is the best one for you? This is where you need people like me, people who are trained and licensed to dish out legal advice. Be hopeful as well, because there's talk, there's always been talk, but there still is talk about immigration reform in Congress, or at the very least, executive action or policy changes at the executive branch, meaning the president and the agencies in charge of immigration. All right, so let's give you a few notions of 101 of immigration law. There are some immigration categories that are used for people to come to this country. And so the most pertinent category that will apply to you is the business or employment-based path, because you're coming here as students and you're likely to graduate, get employed, and secure a visa and then a green card that way. A second category is folks who have family ties in the United States because they marry a U.S. citizen, or because they are related. They have father, mother, or siblings who are U.S. citizens or permanent residents. Also, there's the possibility for those of you who feel as though you would be incurring persecution back home, there's the possibility of requesting asylum or refugee status. And I do have to mention the diversity visa lottery. The time for it is coming up. Watch out at the beginning of October, around October 2nd, the diversity visa lottery opens up. And at that point in time, you can, for free, go on the Department of State's website and register for the diversity visa lottery, which is a method of granting green cards. I say to you, green cards, not just visas, green cards to America on a lottery basis to people who have at least 2 years of education, of high school education. So it's not that hard. Most people around the world would qualify for the diversity visa lottery, but it's only for certain countries who don't send us enough immigrants. To find out if you qualify, if you're from a country that qualifies, I would tell you to Google diversity visa lottery Department of State and go to the .gov website to check if your country is on the list. And if it is, then what I would advise you to do is, if you're thinking at all about permanently staying in the United States, why don't you register yourself and anyone in your immediate family, like spouse, parents, or whoever? Why wouldn't you take advantage of this opportunity for a green card? Now, you might say, but wait a minute, I came here on an F1 or J1, strictly non-immigrant visa. Aren't they going to know I intend to immigrate, and aren't they going to hold that against me? Great question. I would say don't worry about it, because at the level where you sign up for the diversity visa lottery, that is not going to be known until and unless you get selected in the lottery and you express an intent to accept that selection and apply for an actual green card. But by that time, it's too late, because it doesn't matter any longer if the system knows about your intent, because at that point in time, you're ready to jump on a green card. So in other words, your signing up for the diversity visa lottery in October is absolutely below the radar. That radar is not going to communicate anything to your student visa folks at immigration. Okay, so I would relax about that.
Dana, we had a question.
Yes?
Is the lottery applicable to people currently outside of the U.S.?
Yes. It's applicable to anyone, anywhere, who's from a country of birth and nationality that is permitted to sign up for the diversity visa lottery. You just have to figure out if your country is permitted or not. Countries like China, India, Mexico, who send a lot of immigrants to us every year, are not eligible. So find out if your country is or is not eligible. All right, and then there are lesser known avenues to secure green cards in the United States, but we're not going to touch upon them because they don't affect many people. There's temporary visas, known as non-immigrant visas, and permanent visas, also known as green cards or immigrant visas. And this is how they work. A typical path to citizenship starts with coming here just like I did, just like you did, on F1 or J1. So you're on F1 student visa. Maybe during school, you get covered by CPT, curricular practical training, which is a work permit that you could secure if you do work that's aligned with your curriculum and is approved by your faculty advisor and your DSO, designated school official, the people who endorse your I-20s. All right, so maybe you do CPT during school, maybe not. But after graduation, most people should request the OPT because it almost comes stapled to your degree. Once you graduate, and 3 months before you graduate, you could solicit OPT, and it comes after you graduate, and you could use it for, we'll talk about how you use the OPT later on. And then after OPT, many people secure H-1B, which is the most traditional work visa. And after maybe 2 years or so, maybe you get your employer to be interested in sponsoring your green card or permanent residence. And 5 years after securing your permanent residence, it would be citizenship from naturalization. You would be eligible to apply for it. Visa options for foreign students and graduates, that's you. So here's a menu of proposed visa options that we're going to talk about. Now, there's many more than these, because remember what I told you, there's like a visa for every letter of the alphabet, but I picked the ones that are most relevant to you guys. It doesn't mean they're the only ones applicable to you, but the chances of other ones being applicable to you are very small, so that's why I didn't include them. But certainly, if you want to find out if you qualify for other types of visas, that's what immigration lawyers are for. You can contact us, book a 1-hour appointment with us, tell us your whole background, your whole life story, and we could find which visa type is most appropriate for you in your particular circumstance. Like I said, there's also a bunch of types of green cards. However, only these ones, I believe, are most relevant to you, the ones that I listed. Let's talk about CPT. One word of warning, though. When I talk about CPT and OPT, which are two work permits that are very they pertain to what you could do while on F1 student visa. I don't want to contradict your DSO or ISO. Every university has these folks who are in charge of securing your compliance with F1 student visa rules and regulations. And these folks are the authority about what you're supposed to do while in school. I am the authority of what you're supposed to do while after you're out of school and are trying to secure a work visa out there. And so I don't want to say here anything that might be incompatible with what the DSO or ISO is telling you. So listen to them. They usually have regular workshops with international students in which they tell you what your obligations are to report to them, to report to the government, to give them the address, the work, how the OPT and CPT works. So that's who I want you to listen to. And same with OPT. I just wanted to tell you information about the OPT, which is a post-graduation work permit. I wanted to tell you enough so you understand how to utilize it in preparation for other visa types that you might secure later on, and even in preparation for a certain green card later on. So suffice it to say that most, here, let's take a survey. Are we dealing with STEM folks in the audience or non-STEM folks? Do we have both types?
Raise your hand if you're STEM.
They're all STEM?
I'm thinking most of them will be STEM because we're a website devoted to STEM students.
Perfect. So if you are a STEM student, you not only get the first 12 months OPT permit, but you get an additional 2-year extension because you are STEM graduate, science, technology, engineering, and math graduate. Now, let me talk a bit about how you could utilize this OPT to build a case up for a later entrepreneurial-like visa or even a green card. So, during your initial 12 months of OPT, the only requirement is that you do some work that's in your field of study. It is the most flexible time you'll ever have under immigration laws, because during this 12 months period, you could, guess what? You could be working for one employer or 2 employers or 3 employers if you'd like, without additional paperwork or sponsorships. You could be doing entrepreneurship, working for yourself. You could be a business owner. You could be an equity owner. You could do whatever you like that's in your field of study, and you report it to your DSO, school DSO, and they just record it on your I-20 and done. Even if they're 3 employers, those employers will be recorded in your I-20. Now, what happens during the 2-year STEM extension? That's where it gets a little more complicated, because by law, you're not even automatically allowed to be self-employed during the STEM extension. STEM extension actually has a few requirements. The STEM extension could only be used to work for employers who are enrolled in E-Verify. E-Verify is this federal database, online database that employers use to check on your identity and work authorization by law. And if the employer could be enrolled in it, or there are employers who have never gotten enrolled in it because of bureaucracy, and so they still use paper ways of checking your identity and your work authorization. So you cannot work for those paper employers. You cannot. You can only work for E-Verified enrolled employers during your STEM OPT 2-year extension. In those 2 years of STEM extension, it is doubtful that you could be self-employed. I mean, you could, because if you come to a lawyer like me, I would make it so you look like you're still an employee. You have an employer-employee relationship with your company, even if you are the majority owner of that company. We could still make it look like you are an employee. And the way I would make it look is by tweaking your corporate documents. Now, remember how I told you I'm also a business lawyer, so I could think business and I could tweak your corporate documentation in such a way so that it establishes an employer-employee relationship between you and your own company. And so you could, under certain circumstances, be self-employed in the 2-year STEM extension for your own business, but you need legal help for that. All right, other issues is that it's not a straightforward extension. So the first year of OPT, it's very straightforward. You apply for it within 90 days before graduation, and it almost automatically gets granted to you. You don't even need a job offer to get the first 12 months of OPT. However, the 2-year of extension, it's more complicated because you have to fill out a Form I-983 training plan with your employer, which shall be provided to your DSO in order for them to issue a new I-20. And with that new I-20, you apply to USCIS, etc. So it's a little more involved than the initial 1 year, but it's totally doable. So nothing to be afraid of. Let's talk a little bit about the J1s, because we have a few of them here. And whereas the F1s have CPT and OPT as far as work permit, The J1s have what's called academic training, which is the OPT of the J1s, right? Now, the J1s also could come with a problem called 212E, foreign residence requirement for 2 years. You should check your passports and your DS 2019 forms to see if you are subject to this, because if you're subject to this means that you're obligated by law to leave the territory of the United States for 2 years before you can return on any other visa status, okay? So people don't like that because people want to stay continuously on the US soil throughout the graduation and after they're done with academic training. So there are ways to do so, but then you require a waiver of that 212E foreign residence requirement. And the waiver you could secure, the most common waiver is the no objection letter, basically obtaining a no objection letter from the consulate of your country that they have no objection to you staying in the United States and not coming back home for 2 years, right? There's all sorts of other waivers that are lesser used because it's harder to prove them, like persecution, like exceptional hardship, etc. All right, so that's that about J1s and academic training. H1Bs, so let's talk about the most common work visa out there. It's usually a visa for a position that requires at least a bachelor's degree or higher in a specialty occupation. Okay, specialty occupational area means something more specialized, not just general. Like if your job position requires a bachelor's degree in whatever, that position does not qualify. The job description must particularly request or require as a minimum requirement a bachelor's degree or higher in marketing or mechanical engineering or what have you, but something specific, not just general. So just watch out when, because that's what we have to watch out for. When you interview around for job, just make sure that it's a professional level job. Any professional level job would require at least a bachelor's degree in something, in specialty occupation. So how does it work? March of every year, the petitions are getting filed by, well, not petitions, it's lottery registrations, because there's going to be a lottery. I'll explain to you later why we have a lottery for the H-1B visas. Suffice it to say that every March, your future employer would submit your name and their name for a registration for the H-1B visa. And then they draw the lottery before, like at the end of March. By the end of March, everybody knows if they made it or not. If you made it through the lottery, then the next step is you have 90 days. The employer has 90 days to submit a petition, an H-1B petition for you on the merits. At some point, that petition will result in a decision. And at some point, that if the decision is yes, here you are, you're granted H-1B status, that kicks in October 1st. So let's recap. March, there's a lottery. Then April, May, June, there are submissions on the merits, like packages proving eligibility are getting filed for the people who won the lottery. At some point, 3 months or so later, there's a decision. And if the decision is positive, on October 1st, your H-1B status kicks in. Okay, here's the tragedy that we have in this country. The problem is that we have highly limited, very limited amounts of H-1B visas, 85,000 only. And only this past year, 780,884 petitions have been filed against the coveted 85,000 spots. That's a national tragedy because our politicians haven't gotten around to revising the 85,000 since basically the 1980s. So we're stuck with these huge numbers of people wanting the H-1B visas, but with only 85,000 available spots. That means that in any given year, way more people fail the lottery than make it, unfortunately. Which is why a presentation like this that I'm giving is so important, because it's going to advise you guys how to get around the H-1B visa in case you don't make this lottery. And odds are that any one of you, and you know better than me because you're STEM graduates, do the math. Any one of you doesn't have that brilliant of a chance of making this lottery. Even as they give 20,000 spots specifically for advanced degrees. So this is how it works. At first, when everybody enters the lottery, first they draw, what they do is they draw the advanced degrees. They did a reversal lately. So in the last 2 years, this is how it's been done. They put everyone together, the advanced degrees and the bachelor's degrees, and they draw names. Then there's going to be a separate drawing just for 20,000 spots reserved for advanced degrees. And this is how they are maximizing the outcome for people holding advanced degrees. So, Robert, let me ask you this. Is everyone here listening to us someone who's a candidate for an advanced degree?
That is a great question. I assume that part of our audience does have advanced degrees or are candidates for advanced degrees, and some may be at the undergraduate level.
Okay.
And I also had a few questions to ask if this would be a good time to interject.
Yes, go ahead.
So we had 2 questions back regarding J1 visa process. And the first question had to do with, is there an amount of time that you have to wait to apply for the waiver with a J1 visa? Do they have to wait a certain amount of time before they apply?
Well, the answer is it depends on what you got cooking next. So, because you can't just, I mean, you should apply based on a no objection letter with a reason. Well, I need a no objection letter because I just married a US citizen and I'm intending to apply for a adjustment of status, or my current employer wants to sponsor me for an H-1B, so I want this waiver so I could pursue an H-1B visa with them, or what have you.
Okay.
So, but let's say you had an H-1B proposal or some other status lined up immediately after the start of the J1 visa. There's nothing under the law that says you cannot apply already for a J1 no objection letter. So people listening to me now, if you want to apply for a waiver, provided that you have something cooking up next, like you know that you're going to be sponsored for something, start immediately on that no objection letter, because it could take a while to sift through the system. You have to ask for your home government no objection. That has to end up at the Department of State, and that Department of State recommendation has to end up with USCIS, and it's all a cycle. So it takes time to process, months. So get going on it as soon as possible. What are the questions, Robert?
Yes. Could you touch on briefly requirements to convert from J1 to O1, or is that also a very complicated story?
No, J1 to O1 is one of the few exceptions to the need to secure a waiver, provided that you get the O1 through consular processing. It's a little bit of I believe I listed it here. Yep, may switch from J1 to O1. Because it's a concession made to O1 people. O1 are extraordinary ability people. So if you are extraordinary and you could prove it, and you're willing to depart the US soil and go back to your home country to come back through a US consulate processing, then we'll happily give you an O1 without the need to apply for a no objection letter. But then you have to remember that the J1 212E foreign residence requirement doesn't just go away, it just gets postponed. So once you do your O1 and you want to, let's say, jump on a green card, you have to remember you have this J1 212E issue, and you have to dispose of it sooner or later. So again, people here on J1 who know they have this problem called 212E foreign residence requirement, that's why you contact lawyers like me, so we could get that no objection letter going to eliminate this obstacle from your way to better immigration status. Okay.
Perfect. And then the last question, there was, can a J2 dependent convert to a J1 if they get a postdoc?
Anybody on any status can convert to anything else they qualify for. It's not the status you're on that counts. It's, do you qualify for that J1 that counts.
Perfect.
All right.
And then we had a very good point, and I think you may have addressed this sort of. Somebody wanted to know about the fraudulent H-1B visas that were filed this year.
Oh, what a great
second lottery.
What a great question. I want to know about them too. Specifically, I want to know how dare they when they have, I felt too that, you know, we were deprived of that opportunity, but the system compensates for that, because once, okay, so maybe at the beginning there was a 780,000 or so petitions, of which many were fraudulent, filed. And let's say some fraudulent petitions were picked up in the lottery, so they won the lottery. But the moment of truth does arrive. Let me tell you, how does it arrive? Because you have 90 days to file a petition on the merits. When you file a petition on the merits, it will quickly be discovered by immigration that you committed fraud because your name is clearly available through the system. A search would say that XYZ person has also been applied for or petitioned for by some three other companies, okay? And then upon closer inspection, immigration discovers that the three companies are related, like they're subsidiaries or shell companies that have been created solely for the purposes of petitioning for the same person to maximize their chances or whatever, okay? And so that's going to be discoverable, because immigration is not going to sit there seeing XYZ's name appear in 4 other database searches and not do anything about it. They will do something about it by issuing, actually, we're on the slide, they're going to issue an RFE, request for evidence. And as a response to the RFE, someone is not going to be able to prove that all 4 companies who petitioned for XYZ person are legit, and USCIS will rightfully conclude this is fraudulent. Therefore, they're going to take back the visa number and they're going to make it available in the second lottery. Does that make sense? And so the numbers get recycled, and we did have a second lottery just recently in August. So no worries, guys. The system recycled the fraudsters, so to speak. It's still bad. I'm still upset with the rest of the employers who were hoping to capture those numbers, because between the time of April, when they found out the lottery results, and August, a lot of these employers or employees may have gotten discouraged that they didn't win the first lottery. And actually, I personally saw a lot of employer-employee relationships break away or break down because there was no lottery win. So the employee went and found another employer who maybe could sponsor them for another visa, or the employer laid off that employee because if there's no chance of them. And then in August, boom, they get picked on a second lottery. And by then, the relationship no longer exists between employer and employee. So there's still damage. I'm not saying don't worry or no worries. There's still damage to the system, to the integrity of the system, but at least the system has a way to deal with these fraudulent claims, okay? All right. Speaking of H-1B RFEs, specialty occupation is still getting RFE'd, request for evidence, because it's not always clear to the adjudicator that a particular job requires that much specialization, okay? The word is specialty occupation under the law, meaning you can't be just a generalist doing whatever with a bachelor in whatever. You have to have a bachelor in that particular expertise. You gotta have, you know, maybe experience if the employer requires it in that particular expertise. So we do see a lot of requests for evidence challenging, hey, is this job complex enough to warrant an H-1B? We also see this particularly in hybrid occupations where we have an MBA paired with a STEM degree, because then the bureaucrats cannot properly understand, wait a minute, is this a STEM job or is this a business job? We're confused. Please explain it to us. Expert opinion is what I pull in when I answer some of these RFEs, because it is, you know, like, if they won't believe the employer and if they won't believe the attorney, maybe they will believe an industry expert who could say, listen, trust us, this job in this industry is complex, as the employer says. All right. Evidently, and I'm going to repeat this over and over again, in this climate of complex immigration laws and policies, and honestly, a broken immigration system that we have with this lottery problem, you absolutely need to work with a highly qualified, creative immigration lawyer, or else you see a lot of H-1B merit applications fail because there was no competence in how the position was drafted, the job description, etc. So that is very sensitive to legal talent. All right. Let me teach you a few tricks around the H-1B, as I promised, because I don't want you to be a victim of the lottery. So it is generally true that there's only 85,000 H-1B visa available each year, except for universities and university-affiliated entities and companies working on university premises in collaboration with that university. So you get the point. Universities are crucial. They have an unlimited potential to sponsor H-1B under the law. Not only 85,000, they could sponsor as many H-1B as they want, not just on April 1st, March, April 1st, or in October 1st, but any time around the year. So if you want to escape the lottery, you want to be working for a university, an affiliated entity to a university, or a private company on university premises on collaborative projects that further the fundamental mission of the university. There's actually, because you are PhDs in the audience, I want to also tell you there's a few other categories that might interest you. Governmental research institution is another type of H-1B cap exempt employer. Non-profit research institution, this is big, is also cap exempt. So get your H-1B from those places and you will never have to deal with the lottery. There are some spaces around universities that have been created specifically to secure H-1B cap exempt treatment. One of them is here in Connecticut, where I'm from, at UConn Technology Incubation Program, UConn TIP. There's another one at University of Massachusetts, Global Entrepreneur in Residence Program. There are many other university incubators, accelerators, and R&D spaces that could confer H-1B cap exempt status on you. So this is what I call the most brilliant escape from the H-1B lottery. You just have to know about it. Any Mexicans or Canadian professionals in the audience? Do we know?
I'm not sure. Again, if people want to do hands, or they can put them in the chat.
Because I'm going to skip this slide until we get a confirmation that we have interest.
It
All
doesn't
right.
look like anybody says they're from there, so.
Okay. So let's talk about one of my favorite visas ever, L1 multinational managers and executives. This is basically intra-company transferees, a manager or executive that's getting transferred from a company abroad to its affiliate in the United States. It works even if you let's say you're MBA level or PhD level, but before coming to this country, for an MBA or a PhD, you used to work as a manager or executive, or even a specialized knowledge, a personal specialized knowledge in your country or in whatever country at some company abroad. And then you came to study PhD or MBA, and you're about to graduate, and you're asking yourself, can I work, I'm interested in working for the US affiliate of the company I just used to work for abroad. Oh, what a beautiful L1 visa would that be? Because then you straightforwardly qualify for this visa, and no lottery. It's available to you as soon as you qualify. 7 years maximum, and an amazing red carpet to a green card, because there's a mirror image green card that is just like this one, but in the green card world, and you could secure it after a year or two on the L1. Here's the corporate affiliation that's required between the company abroad and the company in the US, either parent subsidiary model, joint venture, stock purchase, or asset purchase. It also works if you never had a functional US entity ever, and this is the first time that foreign company is creating a US venture or subsidiary. That could work as well. And so, like I said, it works very well for a new office, but in that case, when it's a new office, they impose a 1-year trial period on you. Okay, e-treaty or trader's visa. This is for substantial trade, E1, or substantial investment, E2, but you have to check if you're a national of one of the 80 countries that are lucky enough to have a bilateral investment treaty with the United States. Some countries don't have this visa opportunity, like India, China, Russia, and Brazil. The BRIC countries do not have an e-visa options because they don't have a bilateral treaty with the United States. But look how nice it is if you do have it, like most European countries would have it. A lot of Latin American countries would have it, Asian countries, etc. It requires I would like to talk about the substantial investment one, because those of you who are more entrepreneurial and have at least $100,000 of your own money to invest might be eligible for this visa. And it's not only 100,000 in cash, it could be 100,000 in capital. And capital is cash, equipment, inventory, intellectual property rights. So for example, say if you're a PhD in STEM and you invent a great patent that keeps on bringing money and you license it, like you could contribute the patent rights. And if they're valued at more than $100,000, you could be obtaining an E2 visa based on that type of investment. So investment of equipment, inventory, IP rights, loans secured by personal assets count, not only personal cash. E2 visa structures are basically the same as the L1, with the exception of the last bullet point, which is different, because in the L1 scenario, you absolutely needed 2 affiliated companies, one abroad and one here. But if you are if you're an individual, you could also, as an individual, you could invest in a brand new company here in the United States. And as long as you own and control more than 51% of the ownership, you could get an E2 visa and you wouldn't need a parent company in the foreign country. O1, people are like afraid of this category because it says extraordinary ability in the arts, sciences, education, business, and athletics. But what I've discovered working with talented students is that all you need to do is, if you believe you're good and even very good, reserve an hour of consultation time with an immigration attorney and go through your qualifications, because you might not think you're extraordinary, but I may disagree. And if I disagree and I convince you, together we could file an O1 visa for extraordinary ability. And I'll tell you something that I found: students are shocked to see approvals for themselves of O1. But I'm not, because it's, I don't want to say it's easy to achieve, because you do have to be very good at what you do, but it's also not impossible. It's actually more prevalent. There's more people eligible than people who dare to try. And may I say, you get brownie points as a STEM field graduate. They give you more leeway in how you present your evidence, and they give more weight to your STEM education. Okay, before we transition to the green card world, just wanted to teach you that you shouldn't fret the questions from employers about your status. People obsess much about their status when they don't realize that they don't even need to disclose that they're here on an F1 visa or an OPT or whatever, because there's only two questions that are legally allowed for employers to ask them. Are you legally authorized to work in the United States? Yes or no. Will you now or in the future require sponsorship to work for our company? They cannot ask you pointed questions about what's your citizenship, do you have a green card, what type of immigration papers do you have, because those are illegal. So now, green cards. We have green cards based on preferences. Okay, we start with people of extraordinary ability. Where have we seen that before? That was the O1 visa. We also have multinational executives and managers. Where have we seen that before? At the L1 visa. So you see they have mirror images in the green card world. So obviously we prefer extraordinary people first. Then we prefer very good professionals holding advanced degrees, including people who do national interest work, okay? And the third only, we prefer competent professionals and skilled workers, like basically people who just do a good job but nothing special. That's number 3. And you will see that as I go through the slides, the toughest job is at number 3, and even at number 2, the people who do not do work in the national interest at number 2. Those and number 3 actually have to prove a lot to get a green card. We will go over that. But just wanted to tell you that EB1, extraordinary ability green card, could be a self-petition. What does that mean? It means that if you get a lawyer, you don't even need a sponsoring employer. You could just prove with the help of a lawyer to immigration directly that you are extraordinary, and you could be getting your green card. And these are the requirements. You only have to meet 3 out of 10 requirements. You basically have to have some international or national awards, be part of elite organizations, be publishing in major journals, be the judge of the work of others, original contributions to your field, such as patents that you filed, publications about you in the media, etc. How about the EB2 national interest waiver? Another one that could be self-petition and where you need no one for sponsoring employer. You just need a good lawyer, and you could satisfy these 3 factors of proving that you do work that has substantial merit and national importance. You're well positioned with your qualifications to advance that national interest. And number 3 is all about not making you recruit Americans before you could get this green card. Again, brownie points for STEM graduates and entrepreneurs. Okay, you get brownie points at all these levels because we want you in this country. So, and as soon as you dare apply, this is a path available to you. Now you have to watch it because not all work is in the national interest. You can't just work in purely commercial endeavors and think that you're doing something in the national interest. An example would be cancer research, drug research, vaccine research, building bridges, national infrastructure, working on NASA projects, spaceships, stuff like that, that is really a national interest. And this is the toughest category. This is what I call the plain vanilla green card, where it requires your employer to sponsor you. So this is where you have to beg the employer, okay? And the employer has to prove that there's no minimally qualified US workers that are paid the prevailing wage for your position before you could get your green card. It takes these days about 2 or more years in order to get a green card this way. I don't like it. I do a lot of these, but I don't like them because they're very regulated. And I much rather prefer that people find the EB1s and the EB2 national interest waiver before they find this one. I won't even talk about EB5 because it's not as relevant any longer. It used to be, but I don't recommend it to people these days. And one last word about family immigration preferences. If you are related to a US citizen or permanent resident, you should let a lawyer know because there's value in starting to apply for your green card now. I'm also not going to go on proposed changes because they got dropped. Between the time I wrote these slides and now, they dropped these proposed changes. And I'm going to close with the remarks that we are here to help you. We are affiliated with law firms in 100 countries worldwide that help us help you. So thank you so much. And if there's any more questions, Robert, I'm willing to answer them.
Absolutely. Thank you so much. We had a lot of great questions in the chat today and a lot of private messages. Just one, thank you for taking the time today to present this information. I know that as a US citizen, I know nothing about this process, but I've only heard about all of the challenges that international students face. So I do thank you. I had a question. So you had mentioned a few times that people should reach out to a qualified and creative immigration lawyer. And the first question is, if somebody's not in the state of Connecticut, or should they reach out to an immigration lawyer in their state, or does it matter? Or if they're moving to another state, should they talk to an immigration lawyer in that state?
The good news for you guys is that immigration law is federal or national. The same, absolute same standards apply no matter what state you're situated in. Most immigration lawyers conduct consultations via Zoom. There's no need to appear in person anywhere. Documents are not even submitted at the state level. They're submitted at the national lockbox. So there's no relevance to what state you're in. You could work with a Texas-based immigration lawyer and you're in Wisconsin. It doesn't really matter because it's paper-based submissions to a national lockbox, and there's no relevance of state laws in this. It's all federal or national immigration policy.
Fantastic. A question going back to the O1, since it's employer sponsored and dependent, what happens in the case of layoff? Like, is there a period of time that you have to find a new job?
Yeah, there's been a lot of layoffs lately, especially in the H-1B world. It hurts more. It hurts in whatever status you're on. But basically what you would have to do, here's a little known fact. Yes, you have a 60-day grace period, okay, for O1, H-1Bs, and a bunch of other work-related visas. In the 60-day period, if you find another employer, great, you could do what's called a transfer, O1 transfer or H1B transfer. If you don't, you could, as long as you don't overstay your termination of status by longer than 6 months, you could return to your home country and come back in with an O1 or an H1B as soon as you have one line up. But just be careful not to overstay your last day of status by longer than 6 months, because any stay longer than 6 months will inflict a bar to coming back to the United States. If you overstay by between 6 months and a year, 3-year bar. If you overstay by longer than 1 year, 10-year bar. So just be careful, okay?
Wow. And I had a question at the very beginning, and I think you touched on it a little bit, but people wondering about employer obligations in terms of visa. Are you able to touch on that at all, or?
The ones that are most rigorous employer obligations are the H-1B visa obligations. Those are under regulation, and they obligate the employer to pay a prevailing wage. If they terminate an employee, to pay the costs of reasonable transportation back home. What other things? They cannot just not use you or benchmark you during H-1B, so they have to be careful with that. Unfortunately, with all the other visa types, they don't have as many obligations towards you. Like the O1, for example, they wouldn't be obligated to pay reasonable costs of returning home. Neither would the L1, etc. It's just the H-1B that's a little more regulated than the rest.
All right. And then we had a question regarding having loans from a U.S. organization. So would having a loan from a U.S. organization for graduate education have any implications on the visa application, or no?
A loan, no.
Okay.
I know it's counterintuitive because many have brought this to my attention. Well, if they kick me out, who's going to pay back the loan? Is that what the thinking is?
Maybe, I don't know. They didn't, or postgraduate study, they said particularly concerning STEM OPT.
Yeah. No, the loan, unfortunately, immigration does not communicate with your loan company. Fortunately or unfortunately, like there's no connection there. Immigration has immigration to handle, lenders have loans to handle, and IRS has your taxes to handle, and they will not communicate. They do not have any consent, or they're not allowed to communicate among themselves without you giving consent. And the way lender information gets to immigration or tax information gets to immigration is 2 ways. One, you're going to give it to them in response to requirements for obtaining the next visa status, let's say, or green card status. Or 2, if you're going to default and someone's going to sue you, or if you're going to not pay your taxes and the IRS is going to sue you, it's going to appear on your public record, and immigration could see anything that appears on your public record, like lawsuits against you, including for collection of unpaid taxes or collection of unpaid loans, right? So that is the way things get to the attention of immigration authorities, not because immigration authorities are this big brother that goes around and asks IRS for your taxes, or goes around and asks lenders. They don't even know what you have, and they don't even care because they don't have to. You have the burden of giving them the required information on any visa application, right? Any other questions?
That's the same student had qualified the question, saying that they're using loans as a proof of funds during the visa application. So they could see that you may not return, and that's why they were asking.
I don't follow that logic.
But I'll read exactly what it was. I thought I summed it up correctly. They said, I know that most consulates ask if you will return to your home country after school, and so using loans as a proof of funds during your visa application can kind of seem that you may not return. And that's why they were asking about the loans and the visa process.
I don't follow the logic still. I don't think
Okay.
so. Whatever proof of funds you're using, it is what it is.
Okay.
I don't follow at all.
That's okay. That is all the questions that we have among a ton of messages just saying thank you.
Wonderful. Well, I welcome any further consultations for anyone who wishes to have them individually. This stuff is hard. This stuff is very hard and fact specific, and it's very confusing. And I could see that from your perspective. It's not easy to navigate the 26 types of everything and figure out which one is best for your particular situation. And so thank you so much for your attention, and hang in there. People who hang in there usually get their way. It might be more or less painful for others, but I do believe in how much value international students have to add to this country. And at least as to the current administration, I could say that I've seen tremendous progress in how they try to keep valuable, talented international graduates in this country. They're looking at all legal ways of doing that without causing Congress to change immigration laws, which is nearly impossible. But whatever they could do without changing laws, I see that they're doing it. So that's, I also wanted to leave on a note of hope, because even if it's awful what we do at the H-1B lottery stage, which is controlled by Congress, unfortunately, it is great to see what they're doing with all these brownie points they give to STEM graduates at EB2, National Interest Waiver, EB1, Extraordinary Ability. So if you are a talented STEM graduate, there will be a way for you to come through. Thank you.
Thank you so much. Again, all of this information will be posted on our website, beyondthephd.com. It's also, as I said, International Student Month for our organization, and I hope that you reach out to us and share your story. We have a Twitter campaign, or what used to be called Twitter. So take a picture of you doing science, and we would love to feature you and hear about your story. And Dana's information will be on our website, so you can get in contact with her. Thank you again so much, and enjoy the rest of your day.
Thank you. Bye-bye.